Hello everyone, and welcome to today's webinar, Navigating the Privacy Shield and the General Data Protection Regulation. My name is Angela Muir, and I serve as Globalaw's Executive Director and am a Client Director at MCI Brussels. Today we will be addressing key developments in the field of data privacy in Europe and what impact this may have on your association or business. Our agenda will cover the following points: setting the scene, the Privacy Shield and the GDPR, US and European perspectives on the Schrems case, transatlantic data transfers, challenges and alternative tools to Safe Harbor, the General Data Protection Regulation, the issue of consent, looking ahead, practical steps for US associations. Note that a recording of the webinar will be available following. Should you have questions during the presentation, we ask you to type these in the questions box found near the bottom of your GoToWebinar dashboard. My colleague Anna Mingo will pose your questions to the speakers during the Q&A session, should time permit. Our expert lawyers come from 3 Globalaw member firms. They have agreed to share their valuable knowledge and insights with you today. In order of appearance, we have Karen McGinnis from Moore & Van Allen in North Carolina, the U.S., Susanna Klein and Dr. Benno Barnitsky from Goldman in Germany, and David Marchesi from Gordon Dadds in the United Kingdom. With that, it's my pleasure to hand over the podium to Karen.
Thank you, Angela. Good morning or good afternoon, everyone. First of all, I want to congratulate you on your clairvoyance in signing up for this seminar on the very day that the US and the EU have approved the Privacy Shield for the transfer of personal data between the EU and the US. I think you should brag to your friends and your neighbors and your colleagues about your wisdom in doing that. I think it's important first to look and understand the history of the transfer of data between the EU and the US. In 1995, the European Union issued its Data Privacy Directive. Under this Data Privacy Directive, transfers were permitted to the US from the EU or to other companies outside of the EU, only in certain conditions. Those conditions were if there was express consent from the data subject, if there were approved standard contractual clauses between the entity in the EU and outside of the EU. These standard contractual clauses were contract terms that were approved by the European Commission that the European Commission said would have adequate promises and security safeguards to allow the protection of personal information being transferred from the EU to the US. The third option was approved binding corporate rules. So if there was a global entity, information could be exchanged between affiliates or companies within that group, and if they complied and they had these certain binding corporate rules, which my colleagues from Germany will provide some more insight in a little later in this webinar, or, and this is important here, if the country, the non-EU country, ensured an adequate level of privacy protection for the personal information. So in 2000, the European Commission approved the US Safe Harbor as ensuring an adequate level of protection for that data. The Safe Harbor, as most of you on this call know, was a voluntary self-certification program with the Department of Commerce for entities that were regulated either by the Federal Trade Commission or by the Department of Commerce. So things changed drastically after October of 2015. Leading up to this change was the Ed Snowden revelations of mass surveillance by U.S. national intelligence organizations back in June of 2013.
That spurred on an Austrian law student, Maximilian Schrems, who started thinking about and hearing about what Facebook could do with his personal information, and he believed that the current safe harbor could not provide him adequate protections for his personal information because, in part, of this mass surveillance that Ed Snowden revealed, and because he didn't believe there was adequate redress for him if there was some violation. And in October of 2015, the European Court of Justice agreed and invalidated the U.S. safe harbor. This caused a lot of consternation among U.S. organizations, wondering what, in fact, they could do to make sure that the information that they needed to transfer from the European Union to the U.S. could be transferred. So in February of 2016, the United States and the EU agreed to a draft of the replacement for the safe harbor called the Privacy Shield. Again, it's a voluntary self-certification program where companies can submit their certification to the U.S. Department of Commerce. Entities who are subject to the Federal Trade Commission or the Department of Transportation jurisdiction are not eligible to self-certify under the Privacy Shield. You can add to these list of dates that today, July 12, 2016, the U.S. and the European Union formally adopted the Privacy Shield, and we'll talk about when it goes into effect today in the European Union. Companies will have until August 1st, or can start certifying with the Department of Commerce effective August 1st. I have been this morning trying to review desperately the 200 plus pages of documents and updated submissions by the European Commission and the adequacy decisions. I will do my best to let you know where Privacy Shield 2.0 varies from Privacy Shield 1.0, but I think we will, I haven't been able to review it in detail, and we'll hear more about this in the coming days where the differences are. It does appear that an entity has to be subject to either the Federal Trade Commission or Department of Transportation jurisdiction. So these slides that were prepared before today, where an entity that's subject to another statutory body, does not appear to be the case. The express consent, binding corporate rules, standard contractual clauses, at least for now, still appear to be valid ways of transferring information from the EU to the US under the Privacy Directive. I have that maybe by standard contractual clauses because Max Schrems, not satisfied with the invalidation of the safe harbor, is now challenging whether standard contractual clauses can be an adequate means of transferring information from the EU to the US. Again, concerns about these clauses can't prevent the US government from obtaining information. It is interesting to note that the U.S., in a very, very unusual step, has actually intervened in the Max Schrems litigation, which is in Ireland, I believe, to try to convince the court that the fears that Schrems has about mass surveillance and the ability to access individuals' information is significantly overstated. We will see with the Privacy Shield, the Secretary of State and the Department of Commerce and the heads of the national security organizations have all provided a very detailed list of the laws in the U.S. that really prevent or provide due process protections for individuals already and limit this type of mass surveillance that Max Schrems seems to be concerned about. But that'll be interesting to watch and see how that plays out. So digging into the US-EU Privacy Shield, it'll operate again in a manner similar to the Safe Harbor. It does have additional limitations on surveillance by the US government. It has significantly more means of redress for US citizens, and it also has more robust protections and obligations on US companies who do decide to self-certify, more requirements for these U.S. companies than what they had under the Privacy Shield. There are also supplemental principles that provide very detailed requirements for sensitive data, so information about an EU citizen's race, sexual preference, religious beliefs, philosophical beliefs, also for transfer of human resources information. If you're an organization that wants to get HR personnel information from the EU to the US, there will be very significant requirements under the Privacy Shield before you can do that. There are special provisions for pharmaceutical and medical products, and there's other special provisions for other data. I'd like to hit on some special issues before we get into the meat of the Privacy Shield. Now, the Privacy Shield, like the Safe Harbor, sets forth 7 principles. These principles will be very familiar to those of you who are in the EU. They are notice, choice, etc., that you've dealt with for many, many years, and very similar to what was under the Privacy Shield, although absolutely enhanced. The Privacy Shield requires that organizations that sign on and certify under the Privacy Shield have to disclose their privacy policies that are in line with the principles, and in fact have to provide a link to their website. In the privacy policy, we'll have to provide a link to the Department of Commerce website that has information regarding the Privacy Shield, and in the submission to the Department of Commerce, we'll have to provide a link to the company's privacy policies that are in line with the principles. For companies who are transferring human resources information from the EU to the US, those companies will have to have their own specific privacy policy that applies to human resources data. Although it doesn't have to be on a public website, it only has to be made available to the employees of the company. I would say if you're keeping a list of to-do items, I'd put number 1 on your list to get your privacy policies up to speed and in line with the principles. There are in the Privacy Shield framework very detailed requirements for what needs to go in that privacy policy. Companies who self-certify also have to recertify annually. So there's this obligation, as there was under the Safe Harbor, to certify that they are still in compliance with the Privacy Shield principles. There is an obligation to actually audit and verify that the company is still in compliance with the Privacy Shield principles. The Privacy Shield gives companies the option of either doing it themselves, and there's very detailed requirements about how they have to go through and certify that they are still in compliance with the Privacy Shield, or the Privacy Shield says that an organization can use a third-party verification process to do this. It looks like there may be even some computerized ability to process and verify through a third party. I think we will see companies coming out of the woodworks offering this verification process, but that's an important part of the Privacy Shield principles. Again, transfer of HR information is very specific requirements. The organization who wants to transfer HR information from the European Union to the US has to specifically disclose that on the self-certification submission to the Department of Commerce. And as I mentioned, there's also various other requirements that are in the supplemental principles to the Privacy Shield. Unique to the Privacy Shield, this did not exist before with the Safe Harbor, is the concept of an ombudsman. This individual is designated as the U.S. State Department Senior Coordinator for International Information Technology Diplomacy, which is a mouthful, but it's an existing position established in 2014 to deal with international issues regarding the surveillance and national security in law enforcement efforts to obtain data, no doubt arising out of the Edward Snowden disclosures. But this same individual will be the ombudsman who can receive complaints from the European data protection authorities if there are issues or complaints by EU citizens that the national security organizations in the U.S. or law enforcement in the U.S. have not complied with the Privacy Shield principles. So digging in, as I mentioned, there's 7 Privacy Shield principles. The first one is notice, and I would put on your to-do list to start preparing this notice. The notice has to be given to individuals, and it has to include this laundry list of information. The notice has to disclose that the organization is participating in the Privacy Shield. It has to disclose the types of information that the organization is collecting on the individual. It has to identify the purpose for which the collection is being conducted. It has to identify any third parties to which the information is being disclosed. It has to inform the individual of their right to access and correct or delete information. It has to give individuals notice of their right to choose, to limit use and disclosure of the information, and set out how they can go about doing that. It has to disclose, the notice has to disclose the organization's dispute resolution process, very significant enhancements in the Privacy Shield on dispute resolution. The notice has to identify how an individual can complain to the organization, who they can complain to specifically. The notice has to identify what U.S. agency governs the entity and can police the compliance with the privacy principles. And the notice has to disclose that the organization may have to disclose information to U.S. governmental authorities. So very, very detailed, worth getting your notices to individuals up to speed now. The choice principle provides 2 distinctions. There is the obligation to give individuals the right to opt out of disclosure to a non-agent third party or to opt out of the organization's ability to use information from a purpose that's materially different from why it was originally collected. Interestingly, individuals don't have to be given the choice to opt out of disclosure of information to an agent of the organization, but as we'll see, the Privacy Shield organization has liability if its agents mess up and don't comply with the Privacy Shield principles. For sensitive information, if an organization wants to disclose that sensitive information, medical information, race, etc., that we talked about before, or use that information for a purpose other than the purpose for which it was collected, it has to affirmatively get the consent of the individual. The individual has to opt in to such disclosure or such use. The third Privacy Shield principle is onward transfer. If the takeaway here is that any onward transfer of information collected from an individual in the EU, personal data, has to be, you need to have a contract with the entity to whom you are disclosing the information, and that includes whether that's an agent or to a controller or to a processor of the information. And the materials that I've read indicate that the Privacy Shield 2.0 makes clear that this requirement applies to sub-processors. So the Privacy Shield organization has to make sure that its contractors or its vendors or contractors are also certifying that they're complying with the Privacy Shield principles as well. They don't have to be Privacy Shield certified, but there has to be this contractual chain down the line, somewhat similar if there's any federal contractors on the call, U.S. federal contractors, with what happens with employment obligations or other federal obligations that have to be transferred down to not just the prime contractor but to subcontractors as well. As I mentioned before, if a Privacy Shield organization is transferring data to an agent, its own agent, there are more obligations on that Privacy Shield organization to be diligent and have oversight over the organization. And if the Department of Commerce requests a copy of the contract, the organization has to disclose that contract. So having those contracts will be very important. And I think the third item on your to-do list should be bringing those vendor contracts into compliance with the Privacy Shield, doing some due diligence, making sure that your vendors are in compliance with the Privacy Shield principles, obligating them to comply, and ensuring that they're making sure that their sub-processors are complying with the Privacy Shield as well. I can tell you that Privacy Shield version 2.0 has an additional obligation that wasn't in the original version, where these the entities to whom the information is being transferred will have to notify the Privacy Shield organization that if they can't comply with the Privacy Shield principles, and that's true of whether it's an agent or a non-agent to whom the information has been transferred. So that will be an important principle to include in the contracts with vendors and third parties. Under Privacy Shield version 1.0, the organization that self-certified under the Privacy Shield was, and if they certified within 2 months after the Privacy Shield became effective, were allowed to take up to 9 months to make sure that their contracts with third parties were in conformance with these onward transfer principles. And in the meantime, they simply had to comply with the notice, giving notice to individuals that were transferring this information, giving individuals the right to opt out or opt in if it's sensitive information, and still organizations will have to make sure that the agent is providing at least the same level of protection as required under the Privacy Shield principles. I assume that this grace period, this 9-month grace period to get vendor contracts into compliance is still in effect in version 2.0. I have not seen it yet, but it makes sense that the version 2.0 would still provide that grace period for companies who decide they're going to certify quickly to have some time to bring those vendor contracts into compliance. The next Privacy Shield principle is security. At least in the terms of the Privacy Shield, this is an easy one. Organizations must take reasonable and appropriate measures to protect the information from loss, misuse, unauthorized access, disclosure, alteration, or destruction. I think many organizations in the U.S., given the Federal Trade Commission enforcement of the FTC Act, finding inadequate security measures to be an unfair, deceptive practice under the FTC Act, have really engaged in efforts already to try to bring their security into line with what will be the Privacy Shield principles already. Hopefully this won't be a difficult principle to meet, but it is definitely a requirement. Security is definitely a requirement. The next Privacy Shield principle is data integrity and purpose limitations. Organizations have to take steps to ensure that personal data, the information that they're collecting from the EU citizen, is reliable, it's accurate for its intended use, it's complete, and it's current. And this is an important obligation under Privacy Shield 2.0 as well. There are specific limitations on an organization's ability to retain information that is no longer reliable or accurate, or if the organization no longer needs the information for the purpose for which it was originally collected, unless the individual has consented, if the information is not anonymized. So if it can be identified, it identifies the individual's name, or it can be identified to a specific individual, there are specific record retention limitations for organizations. The next Privacy Shield principle is access. Individuals must be given the right to correct, amend, or delete information if they believe it's inaccurate or processed in violation of the principles. The Privacy Shield makes clear that individuals do not have to have a good reason. It's not, you have the right to access only if you have a legitimate justification. This is a right that they will have under the Privacy Shield regardless of the reason, if it's to access their own information. There are exceptions, of course, one of which is if there's undue burden expense that's or expense that's disproportionate to the privacy risk. So if it's an individual wanting to access information that really doesn't affect their ability to get a loan or job opportunities or something along those lines, but the expense would be significant to the organization, then the Privacy Shield says that the organization can decline the person the right to access, amend, or delete the information unless the individual says, I will pay you to do this. I will take the issue of expense off the table by paying you what it would cost you to do this. However, even if the burden and expense is significant, if the information is information that would preclude them getting a job, if it would affect their credit, if it would impair them from obtaining a loan, then the Privacy Shield organization will have to provide the individual access and the ability to correct, amend, or delete that inaccurate information, or if it was processed in violation of the privacy principles. So there's some other limitations, there's always exceptions, but the primary one is this burden and expense issue. I think the most significant change to the Privacy Shield from the Safe Harbor are the recourse, enforcement, and liability provisions, and this was very important to the European Court of Justice. It was certainly important to Max Schrems to try to fix what was seen as an inadequacy in the Safe Harbor. There were numerous organizations that said they were Safe Harbor certified that either weren't, or they let their certification lapse, and there was not sufficient enforcement, at least in the eyes of the EU, against those organizations or organizations that didn't comply with the principles. So the Privacy Shield has very detailed requirements for the enforcement of the Privacy Shield principles. You can see there's a whole laundry list of issues set forth there. I already mentioned the obligation for companies to do an internal or hire a third party to do an audit to ensure annually that they're complying with the Privacy Shield principles. But organizations also, if they receive a complaint from an individual whose data they have to respond to that complaint in 45 days. If the individual isn't happy with the resolution the company is offering for the employees or for the individual's concerns, then the individual can access the company's what is called the independent resource mechanism. The Privacy Shield gives organizations 3 options for setting this independent recourse mechanism, and put on your list of things to do to decide which recourse mechanism you want, or you want your company to have, because you will have to disclose this in your privacy policy and will have to disclose it in your certification to the Department of Commerce. The 3 options are agreeing or identifying a governmental agency as the resource mechanism. One obvious one is the Federal Trade Commission. The second option is to commit to comply with the European data protection authorities and commit to cooperate with them in the resolution of any complaints by EU citizens about a violation of the Privacy Shield. This is a significant obligation, and by the way, if you're transferring HR information from the EU to the US, it is required. This is the one independent resource mechanism that you will have to sign on to, and you'll have to certify that in your self-certification submission to the Department of Commerce. If a company chooses this option to cooperate with the European data protection authorities, not only are they under the jurisdiction of the EU DPAs, but they also have to comply with the recommendations of the European DPA for resolution of the dispute within 25 days and have to certify to the European DPA that they have so complied. And actually what the EU will be doing under the Privacy Shield is setting up a panel of DPAs and organizations who choose this option to use that panel as their independent resource mechanism will have to pay a fee in connection with their certification to help fund the panel. If the organization doesn't comply or certify to this panel that they're in compliance with the recommendation, then the panel can give notice to the company that basically they're going to go tell the Federal Trade Commission or the Department of Commerce. So significant requirements there in terms of signing on to have the EU DPA be the enforcement mechanism. If the issue, the complaint is not resolved at the independent resource mechanism level, then the individual has to go to their EU DPA, their data protection authority, and the EU DPA will work with the FTC to try to resolve the issue. If that doesn't resolve the issue, the Privacy Shield has set up a arbitration process, and all of these resources have to be free to the European citizen who's complaining about the Privacy Shield violation. The arbitration will be binding on the individual. It's only available if the individual has gone through all these prior steps. Every organization that certifies under the Privacy Shield will need to pay a fee when they certify to help fund the arbitration process, and there's a whole annex to the Privacy Shield that outlines the process for arbitration. It looks like it'll follow the requirements or the obligations under the Federal Arbitration Act, if for those companies who are familiar with that law. So if after the arbitration decision is issued, as I mentioned, it's binding, the EU citizen can go to the US courts to have that arbitration decision enforced. So significant processes at the cost of the company for recourse if there's a Privacy Shield violation and complaint. I will also note that organizations, as I mentioned before, will have significant liability if their agents do not properly process information, don't comply with the Privacy Shield principles. There are a whole list of sanctions that are available or that are proposed under the Privacy Shield for non-compliance, the primary of which appears to be shaming. The organization will have to make public any court order or order of the Federal Trade Commission that finds that the organization has violated the Privacy Shield principle. There's some possibility for monetary sanctions and certainly injunctive relief to require compliance with the Privacy Shield. So that is a lot of information. What are the next steps? So the Privacy Shield had to go through this process of review and approval. The Privacy Shield, the principles by the Department of Commerce aren't effective until the approval of the European Commission's adequacy determination, which happened today. Organizations can start certifying under the Privacy Shield through the Department of Commerce effective August 1st. The Privacy Shield principles should be published in the Federal Register in the U.S. very soon. However, even with all this, even with all the significant effort, all the changes, all the upgrades, so to speak, that the Privacy Shield has over the Safe Harbor, all the assurances from the national security agencies within the U.S. government, the Privacy Shield will be challenged in the courts in Europe, and the Max Schrems, other organizations and individuals have already said that they will challenge the Privacy Shield. Whether it will survive a challenge in the European Court of Justice is unclear. I can say that the US and the EU have worked very hard to make sure that the Privacy Shield addresses those issues that the European Court of Justice found inadequate in the Safe Harbor. So hopefully there will be enough for the European Court of Justice to say that the Privacy Shield is adequate. There also is a process under the Privacy Shield where the EU and the US will meet annually to evaluate the Privacy Shield, make changes if necessary, and so hopefully there'll be some nimbleness where there can be changes to the Privacy Shield if the European Court of Justice or other courts within the EU determine or give some signals that they're not wholly satisfied with the Privacy Shield. So with that, I will turn it over to my colleagues, Suzanne Klein and Benno Barnitsky, to give a little more view of the European side of the Schrems case and to talk about some other methods of transferring data from the EU to the US. Thank you.
All right, thank you very much, Karen. Hello, everybody. This is Suzanne and Benno speaking from Hanover, Germany. Well, at the beginning, we would like to go back a little bit, and I'd like to start with a short background of the European Court of Justice's decision, because this is what started it all and what shows the problems, and this is as follows. So we can't move the slides, I'm sorry. Well, whatever, I'm going to start with the facts of the case, which are that the Austrian citizen Max Schrems did not want his personal data at Facebook to be transferred from the Irish server to the US Facebook server. He has therefore raised a claim before the National Irish Data Protection Authority. The DPA rejected his claim because they felt themselves bound by the Safe Harbour decision of the EU Commission. Mr. Schrems then went to court, and the Irish High Court, which expressed deep concerns regarding the level of data protection in the US, referred the case to the ECJ with the question whether, irrespective of a decision like Safe Harbour, the national data protection authorities can, on a case-by-case basis, decide that a data transfer to the US is not permissible. On the basis of this question, the court has taken two decisions. First of all, the court held that any decision of the EU Commission, like Safe Harbour, cannot limit the possibilities of the National Data Protection Authority to independently check whether the requirements of EU law are fulfilled in single cases of transfer of personal data to a third country. And in addition, and although this was not expressly requested, the court felt the need to speak out that the Safe Harbour decision has to be considered as invalid because it infringes European data protection laws. The reason for this is mainly that public authorities and secret services have far-reaching access to the content of electronic communication in the US, and moreover, there are no means for legal recourse for individuals in the US, especially not for EU citizens, as Karen already mentioned in detail just before. Therefore, Safe Harbour does not provide a legal standard for personal data which corresponds with the European requirements. And the consequence is that the European Court does not consider the United States as a safe third country in the sense of Article 25 of the directive.
Now, coming to the legal consequences, this means that at the moment any transfer of personal data based on the Safe Harbour decision is not allowed. There has been a 3-month grace period in Germany which expired in January, end of January, and the DPAs are now informed about, if they are now informed about transfers of personal data to the US, which are still exclusively based on Safe Harbour, they will prohibit such transfer. Now, as you can see from the next slide, now currently the German DPAs are they're currently doing active investigations in globalized corporate groups to analyze whether they still transfer personal data on the basis of a safe harbor. There have already been some decisions, some fines, as you can see here. Like companies like Unilever, Punica, and Adobe have been fined. Although the fines are not very high, you can still see that they are enforcing this the law here, and this also is going on with other proceedings. There's further cases or other cases pending, and you have to expect even higher fines for future infringements. The reason why the fines were so low with the companies I just mentioned was because they simply cooperated with the data protection authorities. Now, according to German law, the fines can amount up to 300,000 euros in single cases, and if an illegal data transfer has been committed willfully, the offense may also be considered even as a criminal act.
So, to avoid this, alternative tools for transatlantic data transfers have to be found, which you can see here in this overview on the slide. First of all, there may be a legal permission, which means that there actually are specific provisions in the German data protection law which allow international data transfer. Those may apply especially if the transfer is necessary for the performance of a contract between the data subject and the controller, or for the implementation of pre-contractual measures taken in response to the data subject's request. But the problem of this is that such legal permissions do not cover all business cases, but it's quite the contrary. So, secondly, there are the standard contractual clauses or model contractual clauses, as they are called as well. Those are quite easy to implement because they are already fixed and approved by a DPA, and therefore you do not need a new approval by the DPAs unless you amend the contractual clauses. But on the other hand, this also leads to the problem, which is that they are not customizable without the approval by the DPA. So they have a very stable and fixed structure, and you can hardly modify them according to your personal needs in your company. Beyond that, they are only bilateral, which means that they always have to be signed by 2 parties to become valid. And for a multinational group corporation, this leads up to a very complex contract management, which means quite an effort for the company.
Now, another possibility to legitimize third country data transfers would be consent. I won't go into detail with this because David will tell you a lot more about this. Let me rather explain you more about the concept of binding corporate rules, which allow worldwide data transfers to third countries within a corporate group. One of the advantages is that they offer a high level of customization, so you have a really flexible privacy regime, and you have also a high level of legal certainty once they are approved by the DPA, because the DPA says you're good to go, you're fine by implementing the binding corporate rules. Now, of course, there are some problems as well. They require high efforts to be implemented, depending on the specific data transfers you have in your organization. and you have also a consultation period with the data protection authorities, which may take some time. And this leads to the result that they may be quite expensive depending on how large your organization is. But how do you implement these binding corporate rules now? So there is a process. The first thing you have to do is that you have to make a due diligence of your corporation-wide data transfers. First, you have to determine whether you are acting as a controller or as a processor, or even both. That may also be the case. So dependent on the role, there are different requirements you have to meet. And then you have to do an assessment of the data transfers within the corporate group that you're looking at. So you try to get a picture of all the data flows, also including the types of data. You need to assess whether sensitive data are involved. You need to define the purposes, find out the purposes also, and you need to review IT contracts within the group, but also IT contracts with suppliers of your group. And with this, you get a picture of how the organization is organizing the data flows, the data processing. And only with this information, you can start drafting the binding corporate rules in coordination with your legal department and the IT department. Now, if you are acting both as a controller and a processor with your organization, you should split up the binding corporate rules documents, because then you have two separate documents, the controller binding corporate rules and the processor binding corporate rules, and this makes it much easier to review for the DPAs. Now, concerning the draft that you're about to do, what can you customize? This is one of the main advantages, as I already told you. So you can define the scope of your binding corporate rules. For example, you can restrict the scope to employee data only. You can also determine the purposes of the processing activities. You can set up procedure rules for complaints by the data subjects. You can optimize the deadlines for certain processing activities, for example, how long data should be stored and when it should be erased. And you also may organize your internal data protection officers within the group, which should be set up worldwide, of course. So far there are no requirements in the Data Protection Directive, which is still in force. Susanne will tell you shortly about the changes under the new regulation. But however, you have some guidance provided by the Article 29 Working Party. You have some explanatory documents which contain mandatory requirements that must be included in the binding corporate rules, like liability, audits. You have some criteria for approval, things that should be in the binding corporate rules, and there are some frequently asked questions. There's a document that answers most of the questions that occur when drafting the binding corporate rules. Now, what is the procedure to get approval? First, you have to hand in the approval documents. You have a standard application form for approval, which is provided by the Article 29 Working Party. There you have to fill in some explanations on the provisions of your binding corporate rules documents. You have to attach your binding corporate rules document to the application. You have to set up a background paper with additional information which explains some of the rules in more detail. This background paper will become a binding part of the binding corporate rules. And then you create a checklist for the DPA which facilitates review of compliance with the requirements in the Article 29 Working Party documents. Now then, the authority which leads the application, the approval process, is called lead authority, and this is usually the DPA which is set up in the country where your group's headquarters is located. Then the lead DPA will appoint reviewers. Usually it's one reviewer which has like 2 more eyes on it, but if you have a approval, if you seek approval for more than 10 countries, there will be 2 reviewers. With this, there follows a communication phase. You will get some feedback from the lead DPA for your draft. And then when the lead DPA is satisfied with all the changes they wanted you to add into the document, the lead DPA writes an approval letter with a legal opinion and sends the letter to all DPAs to the countries where you seek approval for. And with this, the mutual recognition procedure starts. This is a self-binding regulation, which means that there are several DPAs. It's currently 21 countries that have that they simply accept the view of the lead DPA and say, yes, we approve it if the lead DPA says it's fine. And there are, of course, 7 other DPAs which are not under this mutual recognition procedure. They have 1 month to object. Otherwise, approval will be deemed given. Now, then the signed approval letter will be sent to the applicant, and the applicant still must file the binding corporate rules at the DPAs in each member state. If this is required under national law, in some countries it's not necessary. You simply have to tell the DPA that you have just filed binding corporate rules.
So, and then in respect of the coming GDPR, there are 2 good points to mention. First, the main instruments for the legitimization of international data transfers will remain the same as such. Second, there will be a special provision for BCR in the law, which is laid down in Article 47 GDPR right now. So for the first time, the legal requirements for BCR are established. And this Article 47 contains a detailed regulation of preconditions and requirements, especially with respect to the necessary content of BCR. And a lot of them, these requirements, result from the former recommendations of the Article 29 Working Party, which are now implemented into the law and will become mandatory. As before, and as Benno already told you, an approval through the DPA is required, but what will make it a lot easier is the fact that only 1 approval through the competent DPA is required now, and not the approval of any national DPA where the company has data processing activities anymore. The reason for this is the new consistency mechanism laid down in Article 63 GDPR, which shall lead to uniform decisions in the EU in the field of data protection. And moreover, this will be facilitated even more by the so-called one-stop shop in Article 56, Section 1 GDPR, which means that the supervisory authority of the main establishment of the controller or processor shall be competent to act as lead supervisory authority for the cross-border processing carried out by that controller or processor. So it will in future become quite easy to ascertain the competent DPA for the approval of BCR. And the consequence is a standardized process with uniform contents of BCR, which hopefully will make it easier and more cost-effective to implement BCR in the future.
Now, still, if you use these alternative tools, you have, as Karen has already mentioned, some remaining risks. The standard contractual clauses have been challenged by Max Schrems, and for the time being, the German DPAs will not issue any new permission for data transfers to the US and will especially not approve new BCR. So if you think about drafting BCR, you should not apply in Germany. But still, nevertheless, both means, so standard contractual clauses and binding corporate rules are still valid, and they will remain valid under the General Data Protection Regulation if it comes in force, until a new decision of the European Court of Justice has been issued.
But however, the DPA of Lower Saxony, which is where Hanover is located, where we are, she has clearly stated that agreements on a private law are not suitable to guarantee the fundamental rights of EU citizens in the US pursuant to the ECJ's decision. And what is even more important, she stated that companies are required to process personal data only within the EU or the EEA. So this is a clear statement that there should not be any data transfer to the US at all at the moment. And we don't know yet if this is going to change after the Privacy Shield now came into force, because the issues and the criticism remain the same. But with this clear statement, we are ready now, and we would like to hand over the panel to our next speaker, David.
Well, hello. So, David Marchese. Well, I'm just going to try and talk rather briefly, in view of the amount of time left for this webinar, about the issue of consent. Why is consent relevant? Well, we've heard from Karin that some US entities might not be able to make use of the Privacy Shield because they're not subject to the FTC or the DOT. Or indeed, they might not actually want to go through the very considerable procedures which are required under that. We've also heard from Susanna and Benno that there might be difficulties certainly at the moment while things settle down. So can people rely on consent? Well, of course, consent as a means of transfer to third countries is permitted both under the directive and under the regulation. But note under the new wording of the regulation that the data subject must have explicitly consented to the transfer. Just going on to the next slide, what is meant by consent? At the moment, under the directive, this wording, most of which is followed under the regulation, it has to be freely given, specific, and informed, and the data subject has to give an ambiguous consent. But if you look at the way the directive works at the moment, the requirement for explicit consent only arises with the special categories of data, sensitive data. So certainly at the moment, it's arguable that it's possible to have implied consent. And I think that in practice, a lot of entities that don't actually haven't signed up to the Safe Harbour or might be thinking about not signing up to the Privacy Shield will be probably seeking to rely on implied consent, and you can see examples in privacy policies or terms of use of many websites which say things like personal data may be transferred outside of the EEA, and that use of the website will be deemed to constitute the giving of consent for these purposes, and this is clearly an example of it relying on implied consent. Just going on to the under the new regulation, this makes a change in the wording. It has to be a clear affirmative act, which I think is something new, and I think that mentioning of a written or oral statement narrows down the sphere of consent. So consent can be given by ticking a box when visiting an internet website or choosing technical means for information society services. In an online environment, however, it may be difficult to satisfy this test unless the user is actually asked to tick a box. There are restrictions on consent in the recitals, the all-important recitals to the new regulation on the next slide. So this makes it clear that silence or pre-ticked boxes or inactivity will not constitute consent. This is quite interesting because it means that you can't have an opt-out under the new regulation. You have to have an opt-in. And this is quite interesting, going back to the wording of the Privacy Shield, where quite a lot depends on having an opt-out of different uses. So I think this seems to mean that the current practice of including statements of deemed consent to international transfers and privacy policies will have to change in future. In future, the website user will have to tick a box or do something similar. And this may result in greater complexity for online businesses that use, for instance, cloud storage for data, such as ensuring that the user's personal data is retained on servers within the EEA possibly, and not transferred to the USA at all, unless the user actually ticks a separate box consenting to the transfer to the USA for that purpose. And going on, and further details in the recitals to the new regulation. There's some interesting wording about the declaration of consent, if it's pre-formulated, as it were, it's in standard terms, that it has to be intelligible easily accessible, in clear and plain language, and not containing unfair terms. These concepts are very familiar to those of us who are involved in dealing with consumer contract terms in the EU, but these concepts are regrettably absent in some websites, with notable exceptions. So the moral is that unless consumer-friendly language is used, consent may not properly be obtained. And going on to recital 43, there's a point that which says that separate consent will need to be given for different personal data processing operations. So it seems it won't be possible to have a clause stating something like, if you wish to use our service, you must consent to your data being transferred to the USA, if this is actually necessary for the provision of the service. And this leaves open the question of what necessary means in this context, and I think that may be quite difficult. So lastly, looking at a few particular issues. Firstly, the regulation makes it clear that it will be very difficult, if not impossible, for employers to ask employees to give consent to international transfers, as consent isn't a meaningful concept in an employment context. And then online, as I've mentioned above, it's here that the regulation is most likely to bring changes in practice. And it's not, I think, just in terms of website terms of use that care needs to be taken. For instance, I see very often contracts under which providers of outsourced services insist that their customers give warranties that all necessary consents have or will be given when they for what the transfer service provider proposes, either cloud storage of data and so on, involving international transfers. And service providers may just have to understand that it won't be possible in practice to ensure that such consents are given. And finally, online traders who target their services at users who may include children will need to take special care in view of the age restrictions and the difficulty of getting verification for parental consent. Well, that's enough for me at the moment, and I'll pass it back.
Thank you so much, David. Now we are pressed for time, so we have actually time for one question. I see here, would you recommend that U.S. companies choose commitment to cooperate with EU DPAs as their recourse mechanism, under the Privacy Shield? Anyone keen to answer this one?
Well, I'll take a first pass at it, although I'd be definitely interested in what David and Susan and Benno have to say, having dealt with the European DPAs. I think the requirements to comply with, choose the European DPAs as the resource mechanism can be onerous. So there's this commitment that you have to comply with their recommendations and provide assurances in 25 days, or you risk getting reported to the Federal Trade Commission. There is a third option, which is potentially more expensive for companies, and that third option is to have an independent resource mechanism with a private organization like the Better Business Bureau or JAMS or AAA, and that may be more comfortable for U.S. entities, especially if they are likely to be in compliance and they have good internal compliance procedures and can easily resolve these disputes with individuals. But David and Suzanne and Benno, do you have a different opinion on that?
Well, David, I think I'm afraid it's probably too early to say. I think that in practice, larger companies will be looking around for every which way as to how they can protect themselves, and they will be trying to do model contract clauses, and if it's possible, binding corporate rules. Although I have to say that that in practice I find it very difficult to get organizations to accept the notion of binding corporate rules because it appears to be very onerous. I think in the online sphere, and I do a lot of work in that, I think that they will be trying to get consents from data subjects, and at the moment, until the regulation comes in, it's slightly easier to rely on implied consents. I think that over the course of the next 2 years, people will be changing what they do. Please.
I do agree with. I'm sorry, this is Suzanne. I do agree with that because under the GDPR, the fines are going to be much higher, and so any big company will try to be compliant with data protection rules as far as they can. So I totally agree.
I have to defend the binding corporate rules, though. You're right, David. It's a tool for corporate rules for larger groups. However, if you look at the lists of companies that have binding corporate rules, it's continually growing, and I think that is it's a success story, at least for bigger corporate groups. So it's a possibility, but if you can avoid costs, of course, it's better to implement standard contractual clauses. But sometimes it's just not the way that it works because they have different problems.
I completely agree with that. Yes.
Great. Any further reactions or contributions?
Oh, I'm sure no one really wants to hear about Brexit, but if there's anyone out there who's wondering why an English solicitor is still involved in this debate, it's oddly enough that we're still actually a member of the European Union until something happens, and in case anyone is interested, certainly the UK Information Commissioner's Office has said that even though Brexit means Brexit, the United Kingdom will have a keen interest in reforming its data protection laws even further to make sure that they're aligned with our ongoing friends in Europe, and I think that it will be still relevant, and so I don't see that there'll be very great change, certainly in the foreseeable future as far as that's concerned.
Great, thank you, David. It looks like we're out of time for today, so I would like to thank our 4 panelists for their great discussion and presentation. You covered a lot of info today, and thank you for doing it so well and so thorough. Last but not least, thank you to our audience for joining our program on this important topic. We hope that you found it educational and useful. As Angela mentioned already, this webinar will be recorded and will be available on our website shortly. Please feel free to pass along this info to anyone who missed it. And also please note that you'll be receiving a follow-up email with a survey about this webinar and further information, possibly with the link to the webinar, to the recording of the webinar, and an email address. I'm sorry we did not manage to address your questions. We will do so. We have collected them. We will also send you information about our future webinars. We look forward to having you there. So thank you very much, and have a great rest of your day.